Any mention?
This guy.
Item number 1.
May it please, Your Lordship. Lordship, in this matter, we were supposed to obtain some instructions, Lordship. Lordship, we're still awaiting instructions from the department, Lordship.
What objection is this?
Your Lordship, on the last occasion, Lordship...
Oh, yes. There's an objection to the appeal not be maintainable here.
Easy, Lordship.
Why you no instructions?
Your Lordship, we're still awaiting instructions from the department.
With notification. Yes, MSK Guru prays for for the 2 weeks time to obtain instructions. Yes, thereafter also. None appears. Oh, you're appealing for the respondent, right? Yes, the court. Yes.
Much obliged, Lordship.
Item number 2.
Yes, so tall.
This is an application for condonation of delay in preferring the appeal. They've already filed their objection, will it?
Yes.
So the reasons for the delay are contained in para 5 to 16 of my application.
What objections do you have?
My lord, the objection is that, Your Lordship, that the reason which has been given in the condonation application is based on their internal communication.
Useless reasons, I mean.
Your Lordship, internal communication, and then kindly come, Your Lordship, page number 17, the next year.
17.
Yes, Your Lordship.
Yes.
Your Lordship, this is the advice which they have received from the Law Department in the month of August 2023.
Right.
Despite receiving the advice, Your Lordship, no case was filed, no appeal was filed, and suddenly they have taken stand that we have got now the advice.
No, that's not what we're saying. We have the explanation here. The advice was given.
They already got.
In the condonation application. There's objection.
In their application, Your Lordship, page number.
Yes. That's a miscase.
Miscase 2.
Why is the petition not there? Where's the petition gone? It's the order sheet and the petition at order sheet. Order sheet here. Oh, sorry, sir. You check properly before you. Yes.
My lord, page number 17.
Let's see the reasons given. Which paragraph?
Para 5 onwards, page 4 of the application.
Para 5 onwards.
Para 5, page 4.
So. What is the judgment? What does it say?
Well, they had filed a money suit for recovery of certain sums. They had undertaken some construction work for the department CNRD, and that was complete as far back as 2013. There is a huge delay in filing the suit. It is patently barred by limitation. Now, the learned trial court has taken the view that it is within limitation. By taking into account a reply to a Section 80 notice, we can't reckon time on the basis of a reply to a Section 80 notice. I'll satisfy your lordships.
Maintainability was a preliminary issue. Should have raised it here. It did not
Yes, it has been raised. It was argued. But the court has still come to a finding.
Against rejection of that, you have not challenged.
No, 711 was not filed. The issues were framed. Limitation became a mixed question of law and fact.
Give me an appeal. This is a commercial court division appeal.
Lordship.
Yes,
Lordship.
That was dated?
Well, it's 24/5/23. It is at page 23 of the memo of appeal.
What was the amount allowed?
The total amount is 9,85,000 with interest at 12%.
Interest on the payment of dividend. plus security deposit,
Lordship.
bond. This amount is a very minuscule amount.
Lordship.
What's the contract about?
They had constructed office quarters in Garo Hills.
What is the value of the contract?
Well, the issue here is that the actual NIT was never enclosed with a copy of the plaint. It was brought in subsequently.
Whatever it is, but the NIT existed, they must have worked
Lordship,
against
that amount,
It was 60 lakh something.
the tender value was 65,69,000.
Okay, and she says it's a certified bill is not paid.
Lordship.
Yes, can I be? Let's see. That's one. I can't find it right here. Mr. Pandit, there's some issue. I think there's some questions here which need to be answered. So, notwithstanding the delay, 292 days.
Yes,
292 days.
Is will condonedly subject to should we click off? Chalo. That's it. We'll record your objections.
Yes.
Yes, heard Miss Case number FPA number 2/2024. This is an application for condemnation of delay of 292 days in preferring the appeal against the judgment order dated 24/5/2023 passed by the Commercial Court at Shillong, Commercial Money Suit number 1 of 2016. So, the reasons given for delay are that the concerned department, on receiving a copy of the order, had forwarded the same to the concerned department same to the higher ups on 4/7/2023, and that the process consumed much time, as is evidence from as given in paragraphs 5, 6, and 7. 7.2, 7.2,
It's up to para 10.
5 to para 10 of the application, wherein is seen that intra-departmental activity, it's seen that the delay was caused mostly to intra-departmental activity and also the movement of the file stuff. Mr. S. Sen, then its government advocate, submits that the delay was due to bona fide reasons as given in that application, and that there was no and on the part stop. Mr. S. Pandit, General Counsel for the respondent, has raised strong objections and has drawn attention of the court to
Annexure 6 page.
Annexure 6 of the said application to show that the law department had been consulted for an opinion as far back as on 11/8/2023, and that an explanation had also been given at that point of time. It therefore submits that no sufficient cause having been shown, the appeal is liable to be not entertained and dismissed, and the condition appeal dismissed. Having heard legal counsel of the parties and examined materials in the court, it appears from the grounds as set out in the above quoted paragraphs, the delay was caused primarily due to the fact that the movement of the file after the after the judgment was indeed slow, which in ordinary circumstances would not have, in all circumstances in all circumstances would not be a ground for continuation of delay. However, in interest of justice and the coordination being of 292 days, the delay is condoned and the appeal shall be posted for consideration. Stop registry to diarize and it's the appeal for admission. Yes, also. Also, actually, when the order pass, and it's also just a matter of the diarizer. Yes.
Obliged.
Item number 3.
Please, Your Lordship. I prefer a week's time to file my affidavit that is show cause to the.
How much delay?
This from the date of judgment, there is 103 days.
103 days.
And then considering this 30 days, that will be 73.
Yes, W. Jorwa, counsel for the respondent prays for the allowed for 2 weeks time to file objections to application for condemnation of delay. Yes, this thereafter on some sense.
Obliged.
Item number 4. Hearing. Item number 4.
May it please Your Lordship. Lordship, I
Yes.
prefer some accommodation in this matter, Your Lordship. I prefer some accommodation in this matter, Your
Have you
Lordship.
taken steps or they appeared?
Your Lordship, this matter has already been admitted, Your Lordship.
Oh, okay. It's for hearing?
Yes, Your Lordship.
Yes, where's Mr. Pathak? He's not there. Yes, on the prayer of the counsel for the appellant, this is a matter for 2 weeks.
Your Lordship, there's an interim in this matter as well, Your
Yes,
Lordship.
interim order is continued next date. None appears on behalf of the respondent.
Much
Yes,
obliged,
according
Lordship.
to this. And then, Ban biyan question da to ba kan tang tla. Yes, better.
Item number 1. Pronouncement of judgment.
Keeping in mind the judicial pronouncements as extracted above and consideration of fair trial, the interest of justice, apart from other considerations which may be relevant, an examination of the instant case at hand would show that The transfer has been sought at the stage when it was apparent to the petitioner that no further relief would be forthcoming. The very fact that this revision application was presented before this court when applications had been filed by the respondents and with pending consideration the question of jurisdiction before trial court speaks volumes in itself. The case at hand is not one of where the petitioner is apprehensive of not getting a fair trial or that severe prejudice would be caused if the transfer is denied, but it's clearly one of litigants seeking to protract the proceedings and attempt to sustain whatever interim relief that will obtain to his advantage. This aspect clearly demonstrated by the fact that having participated in the proceedings where a request of jurisdiction was before the trial court, the petitioner, instead of continuing therein, has taken a detour by way of the instant revision application to scuttle the same. This court, while noting the facts as placed by the petitioner, had during the pendency of the matter for this court also filed 2 title suits on subsequent events that are unfolded, which however emanated from the same cause of action. The same not adverted to inasmuch as the examination by this court into whether insufficient grounds have been made to warrant the exercise of discretionary power to order for transfer of the suit. As can be seen, the facts and circumstances of the case and on discussion made here and above, in the consideration of the court, no case been made out by the petitioner or transferred suit, especially on the question of territorial jurisdiction of the trial court, and the suit is still pending adjudication. According to the reasons aforementioned, instant revision application dismissed. Yes.
Any mention?
Lord, I beg to make a mention of item 17 of the hearing list. Lord, if it is listed any other date, my lord, after 2 weeks.
Fernandez.
Yes, my lord.
No objection, my lord.
Okay, just after 2 weeks, yes. Yes.
Obliged, my lord.
Must press lordship.
Honor, I beg to mention item number 23 and 24, Your Honor.
20,
23 and 24, Your Honor.
20 and 25.
24,
24.
Your Lordship.
Who's your leading counsel?
DK Wadri.
For how long?
2 weeks' time, Your Lordship.
Yes, on the request of so-and-so, 2 weeks, yes.
Obliged, Your Lordship.
Lordship, I beg to mention item number 18.
Yes, Professor.
Item number 18.
You no objection?
Because instruction from them.
We are still awaiting instructions on the document produced by the petitioner, Lordship.
That can't be. It's been going for too long. Less after 2 weeks. Right on the prayer of the Mr. Khan Energy to await instructions. Yes. Yes.
Ali.
Please, Your Lordship. Lordship, I beg to make a mention of item number 14, Your Lordship.
Vinay Kumar. 14.
14. Yes.
Yes. After puja vacation.
Similar prayer for item number 21 as well, Your Lordship.
20.
Item number 21, Your Lordship.
21 is there. They're seeking
Yes,
time.
Your Lordship. Yes, Your Lordship. I am for a petition, Your Lordship.
After puja vacations. Yes.
Much obliged, Lordship.
Obliged. Much obliged, Your Lordship.
May it please, Lordship. Lordship, I beg to make a joint mention of item number 22, Lordship. Let this matter come after puja, Lordship.
No objection?
Joint request, Your Lordship.
Joint request, Lordship.
Okay, after puja vacations. Because of parties, yes.
Deeply obliged.
Lordship, I beg to mention item 19.
Lordo Convent.
Yes, Your Lordship. Lordship.
Yeah, objection. Yeah, objection to adjournment to adjourn prayer.
Your Lordship, let this matter be taken after 2 weeks.
Yes, the court's asking you to have objection or not. You don't have objection, say no. Yes.
Your Lordship, I'm under instruction.
To say exactly that only. You have to use your mind also to say what you want to say. Yes. Yes. 2 weeks. Yeah.
Lordship, make to make a joint mention of item number 25.
No objection.
What will be mentioning?
Lordship, J. Shilla, Lordship.
You're working with J. Shilla?
Lordship, is for this matter, Lordship.
Yes, after 2 weeks, yes.
Similar prayer, Lordship, for item number 15, Lordship. (15 and 16 are connected matters, Lordship.
Yes, after 2 weeks, yes, 2016. Not ending, yes.
May I please, Lordship? I beg to mention item number 20.
20?
Yes, Lordship.
Not been mentioned yet.
No objection, Your Lordship.
Yes. Yes. 3 weeks, yes.
Much obliged, Lordship.
I beg to mention item 27, Your Lordship. I humbly pray that this matter be taken after 2 weeks, Your Lordship. After 2 weeks, Your Lordship.
No objection, my lord. No objection.
Any urgency?
No.
Then let it be after 4 weeks since 24 matter, yes.
Lordship.
4 weeks, yes.
Much obliged,
Much
Lordship.
obliged, Lordship.
Item number 2.
Please, Your Lordship.
What is this matter about?
Your Lordship, this matter pertains to non-clearance of tender amount, on completion of work allotted to the petitioner, Your Lordship.
What is the amount of work? What work?
Your Lordship, before I continue, Your Lordship, I would like to apprise the court that this is a covered case, Your Lordship.
Covered
As per
case?
yes, Your Lordship. As per the order passed by this honourable court, which is similar on the similar facts and circumstances, but the only difference is the amount and the date, Your Lordship. I may be allowed to place. Your Lordship, in this matter also, the petitioner is a successful bidder for certain works, for execution of certain works in the institution of the respondent.
Yes, you see the judgment? Yes, I heard MSA Khatlian, the counsel of the petitioner, issued notice already issued, no? Issued notice, MSS Shalom, which present acceptance on behalf of all the respondents. No one was called for stop. It is submitted by legal counsel that the incident petition has been filed praying for release of the final amount of the work executed by the petitioner for the respondents and also for refund of the earnest money deposit. Stop. Next paragraph, MS. This first on the same. Next paragraph. First submitted that a similar matter appeared for this court, whereby the court in WPC court by way of WPC number 21523, when this court by order dated 13/2/2024 had ordered petition. The counsel prays that the matter be disposed of along similar lines. A copy of the orders also been furnished to the court. Stop. Next by MSS Shalam Vice Mr. S. said the counsel petitioner prays for 1 week's time to obtain instruction.
2 weeks, Your Lordship.
1 week's time, because after the puja, yes. Yes, after 2 weeks, yes.
Much obliged.
Item number 3.
I pray for 2 weeks' time to file an affidavit.
Mr. E. Movement for responsible to, and it was a pray for not for the 3 weeks' time to file affidavits.
Nice one.
Item number 4.
If it please, my lord. My lord, I pray for some more time to file a rejoinder, my lord.
How many times you prayed?
This is the second time, my lord.
Okay, you are Mr.
A. Sangma, my lord.
A. Sangma for the
3 weeks' time may be granted, my lord.
for the petitioner, prays for Lord for the 2 weeks' time for rejoinder.
Grateful, my lord.
Much obliged, Lordship.
5.
Please, Your Lordship. Lordship, I pray for further 2 weeks' time, Lordship.
Where's the petitioner? Emal Nong appear. None appears for petitioner. Stop. MS Eguru pays for vice also appears for allowed further 3 weeks time to file affidavit. Just thereafter.
6.
Similar prayer, Your Lordship. Much
7.
Lord, here I'll pray for some time, my Lord. I have received a lot of communications, my Lord, but per se I have not received any parawise comments, my Lord.
I don't understand. So what's...
So, Lord, I'll require some time.
See a lot of communication but no instructions. What does it mean?
My Lord, parawise comments per se I have
What's
not
the matter
received.
about pension?
This is real Lordship.
My Lord, he is claiming certain benefits, my Lord. Now, my Lord, the judgment which is relied by my friend, my Lord, it says that it is only, my Lord, it will...
Let him find it, tear up it first. It's no use.
We can be disposed of on his communication. We should be happy. Let's see what he has to say. Yes.
Because that
My Lord,
judgment,
the judgment said
I'm
that
not
it will not be
insisting.
precedent, my Lord. It will
Yeah,
not be
I'm not saying
for
that
other cases, my Lord.
because there are other similar person already got.
He pays for allowed for the 3 weeks time to file affidavit. Similarly also for the respondent number
It's for
represented by MS E.B. Pasahel.
8.
Authorised, Lordship.
Lord, in this case, Mr. Kanta is indisposed. In fact, he's in hospital. So I'll be entering appearance on behalf of the respondent 6, 7.
You'll be conducting the case from here on.
Yes, my Lord.
No, but he's appearing with private respondents, correct?
For the private respondents who are supposed to file an affidavit.
You're appearing on their behalf now.
Yes.
My Lord, also Lordship had given us permission to file an objection against the notification. That objection, my Lord, we filed.
That has been received. A copy has been received by
Yes,
us.
copy to objection by the petitioners to the notification 21/8/20.
Give me a copy, sir.
If you type no need. The date. The light now. When did you file it?
This was filed on Friday, my Lord,
Friday.
27th.
Objection to the notification dated to 21/8/2024 has been since been filed. Stop. Mr. T.T. Dingo, Senior Counsel, who has entered appearance on behalf of the who has substituted. Who is he?
I am one of the faithful, Your Lordship.
No, why should he be impleaded when the matter is on a larger issue? You think your appearance will solve the whole matter?
Your Lordship, it's just that my right also as a registrar is being infringed. So I want to be.
This will happen with many others.
Who is he? What does he do?
It looks like he's a private
Just one
party,
of
Your
the,
Lordship.
He's a busybody.
Busybody, exactly.
We'll keep it on hold. Issue notice on this case also, 160/2024. There's an application for impleadment of notice to issue to the other parties for objections. Yes. This with the maximum matter and so on. We don't want to crowd the issue with this.
True.
Yes, it should be clean cut. Yes.
9.
Yes. Affidavit.
May it please Your Lordship. Your Lordship, in this matter, the complainant had been called on the 19th of this month, Lordship, for hearing, but she had failed to appear before the executive magistrate. So no matter has been refixed to 4th of October on Friday, Lordship.
You inform the petitioner, okay?
Okay.
Yes, MSNG Shilla Leonard Senior Advocate submits that the petitioner since been asked to appear before the executive magistrate. She had been asked to appear on
4th of October,
no,
Lordship.
before date she didn't appear.
19th of September.
19th September, but she however failed to appear. Stop. She has apprised the court that the next date for appearance is fixed on 4th of October 2024. Stop. Like by counsel of petitioner to take note of the same and to inform the petitioner. This thereafter and so and so for affidavits of instructions. Yes.
10.
Much obliged, Lordship.
May I please, Your Lordship? May I please, Your Lordship? Lordship, I may be allowed to withdraw this petition, Lordship. Lordship may allow to withdraw this petition with liberty.
Okay.
Lordship, some negotiation has been going on between the parties.
You're Mr.
PZ Doctor, Lordship.
You're Mr.
PZ Doctor.
No, your name. BP Datta. Can't hear us, you're freaking out.
Yes, PZ Doctor. PZ Doctor, Lordship.
PJ.
PZ Doctor.
What's your... It's not reflected. No, it's not reflected. No, you can't make out these things also. Let counsel for the petitioner, sir. Please allow to withdraw this application. Will liberty to file afresh if so advised. Stop prayers allowed. Understand close withdrawal. How liberty as prayed. Yes.
Bless.
11.
Bless, Lordship.
Yes.
Lordship, you also were required to file affidavit, Lordship. I pray for further 3 weeks' time, Lordship.
3 weeks further time as prayed. Lord for affidavit. Just thereafter.
12.
Yes.
Lordship, I'm praying for 2 weeks' time to file affidavit, Your Lordship.
2 weeks time to file?
Affidavit, Your Lordship.
Listed today for instructions. What's the matter about?
Lordship, there was a tender they had floated for auction of old vehicles.
Old vehicles, okay.
We yet to receive instructions.
Yes, MS Salam, please call allowed further 2 weeks and obtain instructions how to file affidavit. This thereafter and so on. So, yes.
Obliged,
Hearing.
Lordship.
Item 13.
In this case, the suit was filed way back in 1995 by 5 members of the clan. Now, the suit was primarily filed by the members of the clan because the then Lingdo was felling trees, doing everything on his own without the consent and knowledge of the clan. And subsequently, what happened during the pendency of the suit, the plaintiffs filed a petition for amendment of the plaint on the ground that the then acting CM during the pendency of the suit had registered the land in favor of certain individuals only and not the entire clan. That application, my lord, was allowed, the application for amendment, and on the basis of the amendment, an additional issue was also framed by the lower court. Now, the additional issue, which is very important, my lord, is whether the defendant number 13 is the headman, or the CM, can register the suit land during the pendency of the suit, and if so, whether the registration dated 3/2/2000 is valid and legal. Now, my lord, both the trial court and the appellate court did not address this issue, this all-important issue, because even the defendants before the trial court did not dispute that the suit land belongs to the clan. Now, the only issue was who can manage or run the affairs of the clan. Now, the trial court has said that, no, this is a clan land, and the Lingdo of the clan cannot do whatever he pleases. He has to act with the concurrence of the other members of the clan. That was the finding of the trial court. Now, the appellate court, on the other hand, said that no, although the land belongs to the clan, it is only the Lingdo who can manage the same. Now, we have filed a revision petition on the small point. Now, when an issue has been framed,
yes,
that issue has to be decided by the trial court as well as the appellate court. Yeah, my lord, in fact, I don't think...
now, the thing is that
yes.
one thing,
yes.
This, you're taking it back to 1923. This registration of this reading law, right?
Yes, reading law. Because during the pendency of the suit, my lord, what they did is they went before the CM and got the land registered. Only 17 people of the clan. So that became an issue, a very important issue. Because that would give credence to the claim of the Lingdo that he is the rightful owner of the property. But this issue was not addressed by the trial court as well as the appellate court. Now, Your Lordship, Order 14 Rule 2 specifically states that the court to pronounce judgment on all issues.
No, but you were happy that time when the suit was decreed in your favor initially.
Initially, because we are saying that this is a clan land. They also don't dispute that fact. But then, if Your Lordship will come to page 333.
Yes.
333 is the judgment, impugned judgment of the trial court.
When was the revision filed? 22.
Yes.
Or 333.
In fact, my learned friend agrees this has to be remanded back to the trial court.
Admission
Subject-
Peter case the suit
333.
is
The
being
admission
owned,
of Peter-
possessed, managed and controlled by defendant number 1 aside of the clan law deputies, hence the owner possession to clan, not part of the clan relationship with defendant number 1. Who's PW1 at that time?
No. PW1 was the plaintiff at that time, one of the plaintiffs.
No, was he Lindo at that time?
No.
No, suit was
PW1
filed by
5 elders of the clan.
But the Polyarthy womb clan.
Yes.
Okay.
He has admitted that, saying yes, Lingdo is there, but Lingdo also has to act not singly. He has to take the consent of the clan. He cannot do whatever he pleases. That was our case. Now the finding of the appellate court would appear that the Lingdo has the power to do everything.
It will be a bit difficult to complete.
No, what I am saying, my lord, is that if it can be remanded back, because the trial court has to address this issue.
Remanding back means setting aside the appellate order of the appellate court also.
My
Then we
lord,
have to go into that.
the challenge is not on the entire
And challenge,
order
yes.
of the appellate court.
Yeah,
But
what
only
are the,
certain
what
issues
are the,
they-
what are the
it is
fact
picked
you
up.
say that only one issue has to go back, then we have to frame it properly as to why the one issue has to go back, leaving aside the other issues which you say have been decided in your favor. Correct, because if the trial court has decreed the suit in your favor, and then we're not aggrieved, then when the
Another difficulty for me would be that this is a revision petition. I mean, it was filed as a revision petition. Now whether
Oh,
this
revision
court,
petition.
yes, now whether this court sitting in the revisionist jurisdiction can go into the,
yes, can
yes.
As we convert to repeal and paper book business, and all that will
no,
come.
no, we won't convert to appeal. But then it will be
A second appeal.
yes. But it was a subsequent question of law because
Yes.
with regard to, and then of course the case mixed law and fact, but even then, I think we'll hear it. Fix a date. We'll hear it when we have some time.
More time.
And look at the condition of the serial copy also.
Spiral winded, I think.
Unfortunately, this was filed by another counsel. All unnecessary.
Wouldn't finish by now.
Then we'll have to prepare some write-up, otherwise.
No, I'll satisfy this.
No, because the thing is that if the other issues involved, like Mr. Lungo says, then we can't just, even if we suppose you say, okay, fine, but then we have to address those issues also. On the period of the parties listed on when?
After the puja.
After puja vacations for hearing, yes. This matter we don't want to keep pending also.
Yes.
26.
Agani, Alut mein, huh? Yes. Where's Mr. Debnath?
26.
Here for the petitioner? Here for the petitioner? Yes. Yes, Debnath, what's the matter about?
This is regarding this. He was given for the promotional matters.
No, are you ready?
No, Your Lordship. I pray for some accommodation
Then
in
you
this
say
matter, Your
that,
Lordship.
no? You're looking as though you're ready, looking at him, see something. Yes. On a prayer petition, this is a matter for 2 weeks. Yes.
Oblige, Your Lordship.